Good morning. It's our honor to have the opportunity to share our research at this international conference. And today our topic is applying digital methods to determine the best interests of the child. And we will analyze family court decisions on child custody in Taiwan. We have three authors. Two of us, Sieh-Chuen Huang and Robert Leflar, are legal scholars, while Hsuan-Lei Shao is a social scientist at NTNU. I'm in charge of Laboratory of Legal Analytics at National Taiwan University. Therefore, the team name that we participated in this year colleague is called LLNTU. Through this QR code, you can access to our research. We've trained law students to use technology in information science to analyze legal text, mainly court cases, and we acquire useful insights for lawyers and legal studies. Research design, results, and conclusions. This is the outline of our presentation. We will have a brief introduction to child custody and legal background, and also previous related work. And then after that, we will introduce our research design, results, and conclusions. This is the outline of our. If a child has two parents who are married to each other, both of them are entitled to custody. This becomes a problem when the married couple decides to divorce, such that one parent will no longer live with the other, and it's necessary to decide on a new child custody arrangement. In general, like all other issues arising from divorce, including property division, child support, and alimony, custody will either be decided by agreement between the divorcing couple, or, in the case that an agreement cannot be reached, by the court. So how do a judge decide the custodian of a child? According to the CRC, it's the child's right to live with the parents. Therefore, the judge should grant custody to a parent rather than a third party. If both parents meet the minimum criteria but cannot cooperate to each other, the judge tends to pick the more capable one to be the custodian. Prior to 1996, the Taiwan Civil Code stipulated that in both consensual divorce and judicial divorce, the custody of children belonged to their father. And in the amendment in 1996, paternal preference was replaced with the best interest of the child doctrine. Next, let's look at these two figures showing child custody in reality. Both before and after the amendment, the majority of child custody arrangements in Taiwan were made voluntarily between the parents rather than judicially decided. So in the figure 1, official statistics show that when looking at all divorce cases from 2002 to 2019, the distribution of sole paternal and maternal custody has gradually become more equal, and joint custody has become more and more popular. But focusing solely on custody arrangements set by a court during judicial divorces, which is the figure 2 on the right side, a different picture emerges. The data shows a clear preference for granting custody to mothers. Contrary to parents' growing preference for joint custody outside the court tends not to consider joint custody. In order to help the judges decide the case, Article 1051-1 lists numerous factors related to the best interests of the child. As you saw in the previous slide, these factors are numerous and have no order of priority, implicating judges have wide discretion to exercise their own viewpoints on what is best for the child. Therefore, there are some family law scholars adopting empirical approach to explore the law in regard to child custody. The most frequent seen approach is to observe how often the judge mentioned a specific factor in the judgment. The higher the frequency is, the more important it is. But the problem of this kind of research is that the tendency for mother or father is not clear. And also, a very simple but significant question has not been answered. Among these numerous factors, which one or ones take the top priority in Taiwanese judges' minds? In this part, we will elaborate on the process, how the data sample was collected and coded, and the mechanism of decision tree learning. In Taiwan, since 2000, all cases except juvenile and sexual assault cases decided by the district court are open to the public on the official website of the Judicial Yuan. We focus on decisions by all district courts of first instance. We use carefully chosen keywords and limits our decision dates between 2012 and 2017. There are 3,028 cases were found. Moreover, we limited our sample to cases in which both parents are Taiwanese and willing to acquire custody. Finally, we have 835 cases. In these 835 cases, there are 1,290 children are involved. Because sole custody is by far the most prevalent and it is relatively easy to set up a coding rule, we include only these 1,126 children in our final sample. The coding is not based on each case, but individual child, because multiple children in the same family may have different ages, sexes, wishes, interactions with the parents, etc. And in terms of outcome, the dependent variable, 1 represents sole custody to the father, and 0 represents sole custody to the mother. And regarding independent variables, we set up 19 variables that the judge may consider in custody cases from the provision of the article of the Civil Code. social workers' evaluation items, and existing literature. And the rule to annotate the variable is to compare mother and father's performance on each factor and score it. For example, in the variable parenting time, if the mother performs better, we categorize it as 3. If the father performs better, the result is 1. When the performance is incomparable, that is, both mother and father perform well or badly, the category is 2. And then we put the annotated result into decision tree. Decision tree learning is a method commonly used in data mining. The goal is to create a model that predicts the value of a target variable based on several input variables. As our variables are categorical, this study adopts the KIDE algorithm. We ran the process in a random sampling validation in the following steps. First, 20% of the children were randomly designated as test cases. Secondly, the remaining 80% of children were used as a training set for the algorithm. Thirdly, the trained model predicted the outcome of the test cases. Fourthly, the predicted outcome was compared to the test case's previous hidden real outcomes to see if the predictions were correct. And fifth, the preceding steps were repeated 1,000 times. Finally, the results of these 1,000 trials were then averaged to see the performance of this model. This is a demonstration of the decision tree model. The root node of the tree, the feature that best divides the data, is caregiver, indicating that the judges in Taiwan primarily consider who the current caregiver of the child is in the first place. If the caregiver is the mother, represented by number 3, or both mother and father, represented by the number 2, it will follow the line on the left side to the next node, child will, meaning that the model predicts the judge will secondarily consider the child's wishes. If the child prefers the mother, that is 3, or has no preference, that is 2, it again follows the line on the left side, coming to the next end node. It is labeled with a probability distribution, saying that in the validation set, the custody has very high probability, almost 95%, of going to the mother. On the contrary, even if the mother is the primary caregiver, in the case that the child prefers the father, the chance that the mother gets custody becomes fairly low, that is 17%. Next, if we go back to the root node to observe the right branch, when the father is the caregiver, judges next look to the interaction between parents and the child. If the father performs as well as or better than the mother, the father has a relatively high probability, 90%, of